Hello, everyone, and welcome to Aging in Place, the Greater Naperville Area's Family Guide. Our goal is to help the sandwich generation, which is middle-aged adults, typically in their 40s to 60s, who are squeezed by the responsibility of simultaneously supporting aging parents while also trying to raise their children. We want to help parents age gracefully as possible to reduce stress through education and some community connection. It takes a village, folks. And there are a lot of great resources and ideas that we try to uncover with expert guests that know the local area very, very well. I'm your host, Dan Drews, and with me is my co-host and sponsor, Mr. Brendan Roberts, the owner of Seniors Helping Seniors for the Greater Naperville Area. We want to thank one of our other supporters, the Naperville Area Chamber of Commerce, who is a great advocate for all businesses to support seniors in the Naperville area. Brennan, good to see you again. Tell us what's going on at Seniors Helping Seniors.
Well, I'm glad to be here, Dan. So, Seniors Helping Seniors, we're here about helping seniors sort of age as gracefully and with as much dignity as possible, help them stay in their homes as long as possible. So, we do that by offering non-medical home care support, which can range from like companionship, activities, daily living, house management, personal care. And we do it through a real unique intergenerational model. So we really focus on hiring active, mature caregivers that have life experience that can really kind of connect with their clients on a more peer-to-peer level than a medical client basis.
That's great. Well, Brendan, thanks again for helping sponsor these types of conversation. And folks, our show today is going to be a good one as we talk about how to prepare your parents and yourself for estate planning. To help us with that, we are joined today by a Naperville estate planning guru, Mr. Chris Collander. Chris and his father, Dan, lead the very successful Collander Law Office in Naperville, where they've been specializing in residential, real estate transactions, estate planning, and corporate law for over 35 years. Chris, welcome, and thanks so much for joining us today.
Dan, Brennan, thank you for having me. Very generous with your guru qualifications there. Definitely an estate planning professional on my end. I have been doing this for just about 10 years. Got sworn in as an attorney November of 2016, excuse me. So just coming up on my 10-year anniversary of that later this year. Our office, we do about 150 plus estate planning clients every year. We'll meet with the gamut ranging from young clients in their early 20s starting a new family all the way to the people that are going to be aging out, 80, 90-year-old families as well that need to get things done and in place as they prepare for the next step of their family's journey.
Well, Chris, we can't thank you enough for being on the show today and really helping shed the light on the key areas that need help. Brendan, this is a big topic. I don't know where you want to start with this.
Yeah, well, let's talk about the big picture, right? So everybody intuitively knows we've got an aging population. The age of the 65 plus demographic in kind of Western DuPage County is expected to be like 23% of the total population by in the next 5 years. And those people almost primarily want to age in place. They want to age gracefully. They want to basically age in how they would do it. And then when we think about it, we really think about there's kind of three main components to helping somebody age gracefully. And one of those is really, the first one is really this kind of like emotional and kind of mental well-being. So are they, preventing loneliness, companionship, kind of socialization, keeping people engaged. Then there's sort of the safety and medical reasons. Is their home set up for them to live there? Do they have the right medical support system around them? And then, of course, the last leg is really legal and financial. And that's obviously a huge bucket right there. And our business really helps kind of maybe with the top two. But when it comes to the third level, our clients need help. And we see a lot of times that there's things they don't think about until they're in crisis mode. And at that point, it just adds to the stress and everything they need to do. So I'm excited. I think what you've got to say is going to be beneficial for a lot of the people that we work with.
Well, Chris, let's start there. Let's start with the high-level basics. Like, what is estate planning and why is it so important?
Of course. Estate planning is very important regardless of value of assets that you might have, familial situation as well. The estate planning serves as your only way to have it written down legally enforceable of what you want to have happen with your assets upon your passing, also who you want to be the people controlling the process of distributing your assets upon your death. Not only that, but estate planning actually impacts you while you're alive. A lot of people think of estate planning as just a last will and testament. Really, it's an all-encompassing term that's going to include power of attorneys, ability to manage assets or make healthcare decisions for parents, spouses during their lifetime, as well as maybe including a trust as well, which is something that's in full force and effect, has meaning during your lifetime, and also can be helpful in the event something were to happen to an older parent, allowing for children to maybe step in to manage things as well while they're alive.
Yeah, that's a good point there too, Brennan. I don't think people think of that enough, is how estate planning helps them even before they pass on, right? When they're alive, and making sure that there's a process in place that their family can help make decisions if they're incapacitated.
Yeah, I think we come across it all the time where, perhaps the parent becomes incapacitated, or they question their judgment about making decisions, and the family is set to figure it out themselves about what are the intentions and what do they do. And I think, the idea that having the power to say, this is kind of what I want to happen, being intentional about it, is can save, frankly, a lot of issues with the family down the road.
Correct.
Chris, when people come into you, do they come in with different levels of preparation? Some folks that know exactly what they want, and some people that have no idea where to start?
Yeah, we see everybody, people that have no clue about anything from the estate planning, which is usually what I anticipate, because they're not an estate planning attorney, so I don't expect them to know all of the details regarding the estate planning process. Some people are very well into the estate planning process. Maybe they've done this a few different times and they're making updates, and they might come to us and know exactly what they want, or maybe they've done enough research or attended the right seminars to know what to ask or what to think about. I say the right seminars because there's definitely a lot of them out there that might be misleading or provide poor information.
Oh, that's interesting, right? So making sure you're going to a reputable source is a key part of the planning process.
Definitely, yes. Yeah.
Well, and I think everybody goes to AI these days now, and you cannot trust what comes out of that by any means. So,
Yeah.
I'm curious. Like, it's interesting. You see this range of people at different life stages. Is do you see any particular like what sparks somebody to like? Is there any commonality, or is it just a whole range of things? Like, oh crap, I need to do this.
I would say it's usually 3 different buckets of people that we see mostly. You have the younger couples who maybe just have their first child, and one of the 2 couples' parents or both couples' parents say, you have a kid, you need a will. And I would agree with that statement. Most of the time, before you have a kid, do you need a will? Maybe, maybe not, depending on financial situation, how things are set up with a spouse, or if you're an individual, how your accounts are set up. Once you have a kid, you definitely need to get a will in place, because that will serves as your way to appoint a guardian. Obviously, we never hope any of this occurs, but if both parents pass away while the child is still a minor, we have to list who they want to appoint as the guardian in the will, because if you don't have that listed, the court will determine who the best guardian is for the child at that time.
That's a scary proposition right there.
Yep.
Yeah.
So that's number 1, is usually, again, young couple, new kid. Option 2 is somebody that doesn't have a plan in place, and their parent passed away, or they had a friend that went through this process and saw how difficult it can be without doing the proper planning prior to passing away. And I would say those are the 2 main areas. The third area is people that have been wanting to do it for a year or 10 years or 20 years and just haven't gotten around to it.
Yeah. Well, I have a question. So when you have the type of person who comes in for any of those reasons, but they really have no frame of reference where to start, how does that conversation start with them? Do you kind of guide them through the basics, kind of let them know what the goals in general of this process are?
Exactly. So when we meet with a client, we'll sit down for an initial consultation, anywhere between a 30 to 45-minute appointment. Prior to that appointment, we always provide them an information sheet that we ask them to complete to the best of their ability. We don't expect it to be perfect every time, because, again, they may or may not know everything there is to know about the estate planning process. But ultimately, we definitely need to see financial situation at the outset, because we need to know, are there financial things that we have to plan for? Total value of an estate can make a difference, especially in the state of Illinois. But ultimately, we look at that, and then we'll kind of guide the discussion, starting with the basics. Okay, you're going to get a minimum of 3 or 4 documents, regardless of what you want to do. Power of attorney form for property, power of attorney form for healthcare, and a last will and testament are going to be 3 minimum documents we'll start with. A lot of the times we'll do a living will, which is a document relating to end of life direction, as well, not to be confused with the last will and testament of dictates what happens upon your passing. So we always start there of the basics, and then we'll branch off from that discussion of introducing the possibility of creating a trust, different type of trust options, and is a trust needed for that type of a client as well at this moment in time.
That's interesting. Wow.
What do you, when you're talking to somebody, like, I've got 4 kids, you know, they're a little younger right now, but like when it comes
They're
to,
not that young anymore.
I know they are getting older, but when it comes to like identifying a, you know, financial power of attorney or medical power of attorney, like, do you have any advice or experience about like how you would advise them to make a selection, a decision, or do you just default to?
I don't tell them who to pick, but my guiding principle is always, who is the person that you would trust to make these decisions the most if you cannot make them for yourself? And you have to forget about how you think other people might think about your decision.
Oh, that's interesting.
You cannot say, oh, I'm going to appoint child 1, but I don't really want to because child 2 might be mad. Well, you're making the decision of what's in the best interest of not only you and your own assets, but also what's in the best interest of the rest of your family and who's going to manage these things upon your passing.
Yeah.
And that might be different from position to position. You might have one child that you trust to be the financial power of attorney because they're more financially adept. You might have one that you favor for being a power of attorney for healthcare because maybe they are more emotionally there or with it, or are able to make those emotional decisions and handle those types of decisions in those stressful situations.
Yeah. Or proximity wise, like I know personally, like my father lived a couple hours away and I just couldn't get to all his doctor's appointments with him, and you want somebody there that can attend and help him make decisions before, you know, he was able. So
yeah, proximity, location, I would say, can have some influence on the decision, mainly on the healthcare side. When it comes to the financial side, given the day and age we live in, proximity and location doesn't really make too much of a difference because most things are done by email or electronically or things of that nature as well.
Sure.
So you're almost still parenting after you've passed on. I mean, making sure you put those plans in place. Wow.
Yeah.
Brendan, you had some stats and stuff too that you wanted to discuss, right?
Well, I was interested in this, preparing for this, but this is, and we see this all the time. Like, this was from the 2025 annual estate planning report, recent study, and it said, so 83% of people, if you know, and you ask them, is estate planning important? And they all said yes, but yet only 31% of those people actually had a will. Like, do you kind of see this difference in people you talk to?
I would say that sounds about right. I don't know if I could speak to the specific statistics of our office, but based on the initial conversation that I will have with clients that could range anywhere from age of 35 to 85, I would say more than half of them come into our office and don't have a will in place. Regardless of age, regardless of situation, you name it, they come in and say, yeah, we've been wanting to do it for 10 years or 5 years or 20 years and just haven't gotten around to it, and they're finally there to get started.
Yeah. Well, and by the time you're talking to them, they probably already figured out, like, oh, I need to do that. There's this whole entire 79 or 69% of the population that's not coming in to talk to you. So it was kind of interesting. They listed out, like, these were kind of the main reasons why people are doing it. I'm wondering maybe if this lines up with kind of what you think, and maybe you can kind of, if anybody's out there who feels any of these, why they shouldn't be.
Why should they get over themselves? And
I would say the top 2 are for sure things that we hear a lot. Just haven't gotten around to it, or they think they don't have enough assets to do the process itself. If you have any sort of asset, it's beneficial to have something in place. Because if you don't have a will in place and your assets don't have any beneficiaries listed on them, they go back into your estate, which your will would control if you had one. But if you don't have a will and you don't have beneficiary and assets, then the state that you reside in at the time of your death is going to tell us who the beneficiaries of your estate are. Now, let's not think that that means it goes to the state, because that only happens if we cannot find anybody out there that is related to you by blood, no matter how many links in the genealogy chain they may or may not be away from you, and whether or not you never knew they existed. If we can find somebody that's related to you by blood, they're going to be an heir, they're going to get the money, not the state that you live in. But if you can't find anybody out there, then yes, your money might escheat to the estate would be the legal term for that, meaning going to the state that you live in.
Regardless if you loved this person or hated them, they might end up with whatever assets you had. Is
Yes.
this what they call probate? Is that what that refers to?
So probate court is just the county court system
Okay.
overseeing the distribution of the assets, mainly, also appointing guardianship for any minor children. But the probate court process is simply the distribution of any assets that don't have a beneficiary included on them, that were owned in your own individual name at the time of your passing.
Mm.
You go to probate court, the public good concept that is ensured there is that the assets go to the appropriate beneficiaries, and so therefore we have the court system overseeing that process. But if you have a will, or if you don't have a will, you go to probate court unless you do the certain things to avoid it. A lot of big misconception is that a will avoids the probate court process, but that is just a misconception. The will directs probate court what you want done versus the state telling us what you want done.
Got it. Right. So it's given the game plan for where you want your things to go.
You got it.
Got it. Okay. Boy, that sounds like a scary proposition to give, a government entity that much control if you haven't put together a game plan, like you said.
Yeah. And how, in your experience around here, like what is that? How long does that process take to get through? If you're an heir and you have a parent that either has a will or doesn't have a will, takes a long time, right?
If you're going to go to probate court, on average in Illinois, 12 to 18 months, if not closer to 24 months potentially. Really, the quickest you can do it's going to be 7 to 8 months, because once you open the probate case, you then have to file a public notice of death in a local publication, like a newspaper, a circulation of some sort. Once you file that public notice of death, then there's 6 more months that have to pass that allow for creditors to come forward in that 6 months. Because unfortunately, when we die, our debts don't die with us. They're going to continue on, and now they pass over to the estate. Now, they don't pass to your children or any other beneficiaries. Only you and what you owned are going to be liable for your own debts. But if we go to probate court, once we file, usually it's going to be 2, 3, 4 weeks after that of when the first public notice goes out. And then you got to wait 6 months for any creditors to come forward. Creditors that come forward in that 6 months against the estate have a valid claim for any debts or obligations that are owed by that decedent. If they don't come forward in the 6 months, they then lose their right to make a claim for debts or obligations against the estate. So at a minimum, you're open 6 to 8 months because you got to have the 6-month claim period pass. And if no claims come forward, you could wrap up the estate, within a month after that. But on average, you're looking at 12 to 18 months. Whenever you open a probate case, the next continuance date the judge is going to give you is going to be a 12-month date. Because they're not expecting you to get it all wrapped up in those first 12 months, or get it wrapped up in 12 months and close it at that 12-month date.
Yeah. Wow. And if the creditors are coming in and then that goes to the probate, judges say you as the financial power of attorney need to pay that, or how does that process work?
Good question. Power of attorneys cease to have any meaning upon your death. Power of attorney forms are only valid while you're alive. So upon your death, either the will controls or a trust would control, or if you don't have a will, then no documents are going to control. But ultimately, the executor, the person that you appoint within your will, or if you don't have a will, the person that petitions the court to be appointed and gets approved by the judge, steps in, and once they are appointed as executor, they get issued what are called letters of office. At least that's what they're called in Illinois. Letters of office now show that you're the acting authority over the assets of the estate. So whatever assets were owned by that decedent, If I'm the executor, I have letters of office. I can now get access to those assets, managing the assets, making the distributions as well. Or in the event of creditors coming forward, well, now we have to look at the line of creditors because there's certain hierarchy of who gets paid first. Now, if the estate has enough money to cover all the debts, well, then all the debts are going to get paid. And whatever's left over goes to the beneficiaries at the end of the day.
Wow.
If the estate doesn't have enough assets to pay all the debts, well, then we shrink the debts down on a prorated basis and pay them all out, and the beneficiaries wouldn't get anything.
That seems like an absolute mess if you don't kind of prepare for that moment. And Chris, that's one of the things we talk about is, not only the seniors and how they can prepare, but our sandwich generation audience members from 40 to 60-year-old. Do you see a lot of that, and or what kind of coaching would you give for people kind of in our, I guess, generation that are kind of trying to prepare their parents? Because some of I'll just use my example. My parents could be very stubborn, and so I kind of had to approach it a little gingerly when kind of saying, hey, what do we have in place, and how can I make sure and support whatever your plans are?
Yeah. As far as approaching a parent and things of that nature, ideally, if you can do some of the legwork on your own of figuring out their own financial situation and status as far as what assets do they have, how are those assets owned, are they jointly owned, are they individually owned? Obviously, that might be easier for some kids to do for their parents than others. As far as best way to approach it with the parents, if you have a lot of that info up front, then you can kind of do some of that legwork that they don't want to have to worry about doing. Because that's, I think, another maybe barrier of people thinking of, I have to get all this stuff in place or get all these details ahead of time, which yes and no. A lot of people think you need certain account numbers and dollar amounts down to the penny. But that's not the case, because we're not going to list your assets in the documents. The documents are going to be all encompassing, controlling whatever you own, even if we list them or don't list them. So, but we do want to get a rough value of those assets. So number one is if the kid can kind of do some of that legwork on their own, that's a good starting point. As far as the best way to approach it, that's going to vary from family to family, from child to parent, based on their relationship, based on parents' current situation, whether that's health-wise or mentally wise as well. Because I think you are correct in thinking that when we're getting to that dealing of parents that are older, they are more likely to be more stubborn and maybe not want to do it at all.
Yeah, or at least closed off. I find some folks are just really protective of that information, which I get to some degree, but I think they could be unknowingly causing problems for their kids that they didn't intend to.
I think it's people don't like thinking about their own mortality. They don't want to do it. So I mean, there was this other stat. I was like, wow. I think it's like having some conversation, and even at this point, like 52% of adult children don't even know where their parents store their estate documents. So maybe you had I think this is what Dad's wishes were, but I'm not really sure, and I don't know where they're at. So, that shouts to me at least hey, Mom, Dad, have you done estate planning? At a minimum, have you done it? And where can I find that stuff in case of emergency?
Yeah. I will get too many calls each year trying to find Mom and Dad's will, Mom and Dad's trust after Mom and Dad have passed away, or maybe Mom and Dad are maybe not mentally coherent anymore, living in assisted living or memory care, and the parents or the kids know there's something but have no idea where to find it. And unfortunately, it's all kept private. There is nothing out there. There is no public database. There is no database at the county. There's no place that we filed the wills. There's no place we filed any trust or any power of attorneys. The will only gets filed upon the person's death, never before that point in time. And they try to ask me, well, how do I know who did the work? Well, either Mom or Dad's got to tell you, or you got to find something and try and call around. But again, there's no publicly available of who did the work or anything of that nature. So ultimately, what we always recommend to our clients when they leave and complete the estate planning process, we recommend they're going to want to create a list of certain things. Number one is asset details, account numbers, logins, usernames for passwords and online accounts, given how everything is digital now and technologically advanced, including how assets are owned, whether they're jointly owned, individually owned, are they in a trust, do they have a beneficiary listed on them, and then also, where are the documents kept? Where do we keep the paperwork? And now maybe you don't want to share a lot of the asset detail with your beneficiaries while you're alive, but sharing the paperwork with the people while you're alive, in my opinion, usually no harm in doing so. There's no identifying information. The only time people don't want to share is because they've picked one child over the other and they don't want the other child to be offended, kind of like we had talked about at the beginning of our discussion.
Yeah. We came across this stat we were looking at. It was like the amount of like life insurance that goes unclaimed it's like I don't know, what was the number? It was like it was in the billions, just
That's
sitting
right.
out there because nobody's put a claim on it. They haven't connected. Just a death notice. Like when my father passed away, I remember he had told me, and he had done a nice job of listing out his stuff when he got remarried, but that was 20 years old. So that life insurance policies had probably been bought and sold like 3 times in that process. So
That's correct.
It was like a treasure hunt trying to like track down, and then at the end you kind of run into a dead end. You're like, all right, we don't have a record. I'm like, okay, I'm like, well, does that mean he stopped paying it, or I couldn't find it?
Exactly. So that's why it's always important to list your assets. And I always tell my clients, update it at least once a year. Usually around tax time is the easiest time to do so because you're gathering all your financial information anyways. But to that point, I could give 2 easy stories about the importance of that. When I first started working, we did a probate matter in Cook County, which we don't do those anymore because Cook County, and again, solo practitioner, so time is limited and ability to do that. However, we did a probate matter in Cook County, did everything, and about 2.5 years after we closed the probate case, get a call from the daughter of the dad that had passed away, and they found a stock account that dad had worth $300,000.
Whoa.
2.5 years after he passed, they found it.
Oh my gosh.
Because if you don't tell us what you got, we got to try and find it.
That was a pleasant surprise.
And whether that's sifting through your mail for 12 or 18 months to figure out what the heck you own, it's a lot easier if you can tell us.
Yeah.
The other one is I stepped up for another attorney in the area. He had a conflict, so he asked me to cover his court case that date. It was very simple, just stepping up. He needed a continuance. That was about 2 months ago, and that probate matter was first started in 2008.
Oh my goodness.
Because on that one, there is a retirement plan that the dad had from a job and working, and that retirement plan had been sold so many times that they have been trying since 2008 to find out who the current holder of that retirement plan is.
Oh my God.
Here we are 18 years later after dad has passed, and the executor is still trying to hunt down that plan.
That's got to be maddening.
Good for him for being persistent, but man, that's crazy. That's crazy.
I think the whole planning piece too, it really speaks to being able to deal with the worst case scenario when the worst case scenario happens, right? And we got in this conversation with my mom and dad about not only the financial part and logistics, but also what do you want us to do with you, burial and such, when you pass on. And I think that's a big part of the conversation to make sure that there's not unneeded pressure on the kids. You'll appreciate this being the avid golfer that you are. My dad says he wants to be cremated and sprinkled on a couple specific golf course holes. So I had to write that down and find a way to make that happen for him.
Just a couple of specifics. Not number 4, though. That one would always eat me up. So.
Chris, in your situation, do you ever have to get involved and or try to referee family dynamics very often? Or are you more just try to keep them on task with what they're trying to do?
Try to keep them on task. Occasionally, yes, but ultimately that's not my job. Whenever that starts to occur, it's usually you have maybe a child that's trying to be providing input. Well, the child's not my client. Mom and dad are my client. Occasionally, not often, a child will come to the appointment, the consultation, the signing. Most of the time that happens, nothing wrong. Maybe mom or dad just need a ride. They don't drive, or they aren't able to drive, or who knows what. And however, though, there are certain instances where you can start to feel it, and then where you've done it enough, where maybe there is some sort of a different relationship going on here, or a different background that maybe we need to try and figure out or suss out. In those instances, you might ask so-and-so to step out of the room. I need to talk about something specifically with mom or dad alone. But as far as that, we always have to remind, in those instances, the easiest way to deal with it is I have to remind those people that are trying to step in that they're not my client. That my job is to represent mom or dad or brother or sister or whoever it might be, and that is my client, and my job is to put their wishes onto the paperwork, not to put the person who's trying to influence wishes onto the paperwork.
Good for you. Good for you being an advocate, a strong advocate for those
It's
people.
not always easy. It's not always...
probably create some awkward situations.
It does create some awkward situations as well. Most of the time you feel those situations out and you determine there's nothing wrong going on. But you have to make sure, ultimately at the end of the day as well, because the documents are only enforceable if they were done of that person's free and voluntary will. If there was any duress, undue influence, you name it, well, now it's a challengeable document in the court of law.
Yeah.
Interesting.
I'm curious about, we talked about the extent of estate planning. We didn't talk about like trusts, like family trusts. Like when do those come into play, and like when do you recommend those? And
Sure.
what are the pros and cons of those?
The biggest benefit that 99.9% of people all would get from a living trust is to simplify the distribution of assets upon your death. Because again, we were talking about probate court earlier. You only have to go to probate court, again, for anything that you own in your own individual name and that you failed to list a beneficiary on. You avoid probate court for any assets that have beneficiaries on them. If an asset has a beneficiary on it, all that beneficiary needs is usually a death certificate, notify the financial institution, fill out some paperwork, get access to the funds or the account within a relatively short period of time of starting that process. The other way to avoid probate for most people is owning assets in the name of a trust. So a living trust is a way to set up, and it's a document that is valid while you're alive. In most situations, that living trust doesn't actually change anything for your purposes while you're alive, except maybe the title on certain accounts. Real estate, wanting those things owned in trust. Bank accounts, usually as well owned in trust. When it comes to investment or IRA assets, those are things where you want to consider other financial considerations as well. But anything that's owned in a trust also avoids probate court. Now, while you're alive, you're the trustee and you're the beneficiary of that trust. And all the trust does is basically state that the trustee, the person managing the assets, has to do so in the best interest of the beneficiary. So if you're the trustee, you're the beneficiary, manage all your own assets for your own benefit while you're alive, nothing changes. But upon your passing, then our trust terms change. If it's an individual trust or if it's a joint trust and both the creators pass, then the trust terms change. You have a successor trustee. And instead of going to probate court, whatever assets that are owned in a trust pass outside of probate court as well. Once you pass and I have a death certificate, I can then be the acting trustee. If I was the initial successor, you pass, I have a death certificate, I'm now acting. And the moment I have that death certificate, whatever is owned by the trust, I can start managing, getting access to almost immediately. And that happens outside of probate court as well.
Yeah.
So for the 99.9% of all people, the biggest benefit is simplifying, avoiding probate, avoiding that 12 to 18 month process, avoiding the up to $10,000+ of cost for probate court as well.
Yeah.
So those are ways to simplify the process. Now, there are all sorts of trusts out there, and another big misconception is I don't have enough money for a trust. That could be the case. If you're 85 years old, you own one home, you have a bank account and an IRA, and that's all you have, and you know that you're going to live in this home until you die, well, then a trust is probably overkill, because we can have a beneficiary on real estate in Illinois, and if all the other assets have beneficiaries on them, and we don't need a trust. We avoid probate court by having the beneficiaries. But let's say you might be moving out of state. You are not certain that you're going to pass away in this house, or you have things that you want to control beyond just giving assets equally to beneficiaries. Maybe you want assets to go in different percentages to beneficiaries. So in those instances, a trust can be helpful by avoiding probate and also bringing in those additional terms that you want to have in place. Because if we want to avoid probate by beneficiaries, most assets only allow you to designate people as equal beneficiaries.
Mm-hmm.
Let's say you want 90% to go to so-and-so and 10% to go to the other person. Well, then we want to list a trust maybe as a beneficiary in that situation as well to control those splits and percentages there.
Yeah.
Interesting. Okay.
Now, there's other reasons to create trust as well. Estate tax planning, which of course Illinois is one of 15 states that have an estate tax. 35 don't. DC does as well.
Mm-hmm.
If you're under $4 million in assets, which most people don't have to worry about for the most part, then we don't need to worry about the estate tax planning. But if you're a married couple and you're jointly over $4 million, well, now we need to consider estate taxes.
Mm-hmm.
Because the moment you start passing money to anybody that's not a spouse, and if you pass away more than $4 million, then there's an estate tax that would be hit, and it is not cheap. Several $100,000 usually at a minimum on an estate tax side.
Wow.
Yeah.
And that $4 million exemption in Illinois is per person.
Yeah.
So if you don't use it when you pass, you lose it, and spouse can't use it. So if you do additional planning, though, you can combine the two $4 millions between the spouse to be up to $8 million to combine together on the Illinois level.
Yeah.
The federal estate tax we don't have to worry about for the moment for most people because that's $15 million per couple. And I phrase that as per couple because it's $7.5 million per person. But if one spouse passes, as long as the surviving spouse does not remarry, they can use both spouses' exemptions upon the second person to pass. That's on the federal level, but not allowed on Illinois level.
Yeah.
So if you feel you pay enough in taxes already, best to do some planning to not give the government any more.
Yeah. It's probably safe to say you don't get a lot of people coming in and listing out the state of Illinois as a beneficiary on their states, right? So, but I mean, it's true. I think you work your whole life. Hopefully you've saved up a little money and you want to pass it down. I think one of those reasons it's like, oh, it's too costly. It's like, well, it's going to cost a lot more money and potentially taxes, tied up in probate court. It really, if you do the math on it, it really makes much more sense. To
generally
plan
speaking,
ahead.
an estate plan is going to be cheaper than going to probate court.
Yeah.
So spend the money now, don't spend it later.
I think of it just from a parent perspective too. I mean, you go through your whole life trying to take care of your kids. You should also take the time and energy to make sure your estate is set up in such a way that on the unfortunate time when you do pass away, that it's not a burden to them, that they've got a game plan, that it's not some situation where family members will be bickering with each other, right? I think that's probably one of the last most important parental things you need to do.
Yeah. You'd met any other unique things about like DuPage or the state of Illinois? I mean, you mentioned we have an estate tax in the state, but anything else? I mean, I think we talked about this.
Other way. I mean, Illinois does allow for avoiding probate court as well if the value of an estate is under $150,000. So if your estate's under $150,000, don't own any real estate, then you can avoid probate court as well. Generally speaking, it's still a good idea to have a will because, again, if you don't have a will, then the state's going to tell us what to do with those assets. If you have a will, and even if you're avoiding probate court by having under $150,000 in Illinois, you still file the will. The will is still going to control the distribution of those assets, but still avoids probate court. So that's at least a beneficial thing to have that will in place as well, even if you don't think you need it.
Yeah.
Brenna, it sounds like one of the biggest things, I know you've seen it too, is just making sure there's communication between yourself and your parents as to what's the game plan and what to do when that terrible day comes.
Yeah, and I think you got to be able to do it in a way that doesn't feel like how much am I going to get. It's really about again, people. You work your whole life. The last thing you want to You want things to happen the way you want them to happen. And, we talk about living and aging as gracefully as possible, but it's really about dying gracefully and helping things go on afterwards. So.
Mhm.
Yeah.
One of the phrases that you and I have heard used, I think, pretty well is, "Mom and Dad, what is your ideal vision of what happens when you pass on?" Right? And make them kind of tell you the story of how they would hope things would go, and then try and align your strategy with that. So,
Mm-hmm.
yeah. Brendan, what else? I think we've covered quite a bit too. I guess, Chris, any other words of advice you have for our listeners on any way to get started, or why not to kick the can down the road on this?
Yeah. Ultimately, you never know what's going to happen. It's not a matter of if, it's a matter of when, as far as whether that's passing away, whether that's something going wrong, whether you need, maybe there's not anything wrong, but maybe you need somebody that can help out. Or maybe you're getting to the point of just not wanting to handle your own things because maybe you don't have the ability to do so. So, as far as number one, yes, it is a daunting topic, but ultimately let the professional guide you.
Mm-hmm.
As long as you make that appointment and you show up, they're going to try to make it easy on you as possible. As far as getting the process started, again, it's going to vary from family to family, from situation to situation. What I always tell my clients, though, is that you did it. Now the goal is don't use it for as long as possible.
Mm-hmm.
So just because you do it doesn't mean you're dying tomorrow.
That's
Yes,
a good point.
It's not exactly a fun topic. It's not something a lot of people want to think about. My own spouse included didn't necessarily want to think about it, but we got it done, and it's in place in case something happens.
So you mean to tell me the estate planning attorney even had to have a difficult conversation with his wife on getting it all done, huh?
Of course. We were new parents.
Yeah.
We have a 3-year-old and a 1-year-old. And, we were enjoying our life. And of course, you don't want to have to think about, what if I pass away and leave this young child here?
Yeah. No, good point.
By having the necessary steps, we have it written down of, if something were to happen, hopefully our wishes are followed of who they're going to go to live with and who's going to manage their assets from a financial side, and how are those things all going to be dealt with and handled in the event something were to happen that we don't plan for.
That's great. Well, listen, this conversation has been tremendously helpful. We can't thank you enough. If people need to get started, what's the best way for them to reach out to you, get started, and kind of use your expertise to kind of help them down this path?
Of course. So our website, usually the easiest way, we have a contact us form on there, collanderlaw.com, fairly easy to remember. Go on there, we have a contact form. If you submit that contact form, it comes directly to my email and one of my other paralegals' emails as well. And you should hopefully get a response from us in about 24 to 48 hours.
That's fantastic. Well, Chris, thank you for all you do for the Naperville area community and such too. You're a huge asset. Brennan, thank you again for helping sponsor and foster these types of conversations to allow not only the sandwich generation, but our seniors know how to tackle these type of topics.
Yep.
We definitely appreciate it, and for seniors helping seniors as well.
Yeah, they're not easy topics. They're not complicated. That's why there's professionals like Chris around to help guide us through it.
Absolutely. So, Chris, thank you again for taking the time with us today. We really appreciate the fact that we're going to help seniors age in place with information like this. Brennan, you've been great. We look forward to you all joining us next time for our next guest. And so until then, remember, it takes a village, so do your part in the village. Thanks for joining us, everyone. We appreciate having you.